The fair processing notice then, just to make sure that the timing of that is important, and there's a strict timescale on it. In general, you have to give that notice, all that information, when you first process the data. Innovations were a mail order company who collected in customer details and passed it on to other people to mail them with various marketing stuff. But what they did, they were passing customer details on to other people, and when orders were first placed with them, they sent out notices at that stage, but not when actually receiving the data. So you basically give them the information of who you were, etc. Then it was only when you actually placed an order with them that they then said, "Oh, by the way, we're sending out your information to other people." And they were saying, "Well, that's when we first processed the data, surely." But in fact, the Data Protection Tribunal said no, and the company was censured for doing that and were made to change their practice. The reason was, they said, well, you could easily have told people at the outset that was what you were going to do. It wouldn't have been difficult for you. Why didn't you do it? You should do it that way. Despite the fact they did in that actually give the individuals the opportunity to object before the marketing took place, but the tribunal said that's not sufficient. You have to do it, be upfront about it, do it straight away. So if you are wanting to use people's information for direct marketing, have it there straight away. This is what we're going to do, and as we'll see later, ask them if they're happy to consent to that. Final point mentioned on there is about lists obtained from third parties. That's sort of the other way around, where you're buying in data from somebody else to then market to. If you're doing that and you're buying in lists, then again, before you actually do anything with that data, you should be informing the individuals concerned of what you're going to be doing. The reason for that is the risk is that if the original business which got the data in and then sold it to you, if they've not followed the correct practice and not fulfilled their obligations, and there's a complaint made against you, unless you've been clever and got an indemnity from them, which I'll just put in a minute, if any claim for breach of the Act is going to come against you because you're the person that's done the marketing, even though you say, well, it's not my fault, I just bought it in good faith off them. Tough. The way to get around that is, if you are buying in marketing lists, when you get a proper agreement drawn up to purchase that list, and in that, particularly for users, have an indemnity term in there to say that any claims that are made as a result of anything that you've not done regarding this data, I'm coming after you, which gives you then the ability to obviously turn around and point that claim at them. So now I'm going to look at those conditions that we talked about earlier on, Schedule 2 and Schedule 3. Now the Schedule 2 conditions apply to all personal data that you're collecting. If you're collecting in personal data, then you've got to comply with at least one of these if you're collecting and processing the data. The obvious one's obviously, number one, consent of the subject. Basic, easiest one to get, you would think. If you're not getting consent, then you need to show that one of the others. Either the processing is necessary, so that's necessary, might be necessary, for example, for the performance of a contract to which the data subject is a party. So if somebody's ordering something over your website, you're going to need their name, their address. You can't send them the stuff otherwise. So collecting and processing that data is going to be necessary to actually go through the contract. So that's probably the way around. If they're applying for something from you, again, you need their information to be able to. Right. Moving on just a little bit further. Cookies, which if you're regular users of the internet websites, you'll probably know more about than I do. The official definition of a cookie per the electronic regs is there. Electronic communications network to store information or to gain access to information stored in the terminal equipment of a subscriber or user. Probably all know what cookies are already. Obviously it's a bit of kit that gets placed on your hard drive and remembers where you've been when you return to a website and what you've done. If you think about it, that's actually quite an invasive bit of kit because it's obviously tracking what you're doing and remembering where you've been. And the EU took an intense dislike to cookies when they were drafting these regulations, and consequently cookies actually are the starting point is that cookies are illegal. You can't use them unless the person that's using the cookie provides the other party, so the visitor to the website, if you like.
Are we talking specifically about a certain type of cookie? Because cookies are a general technology they can be used for all kinds of things. If you're talking about gathering information from a cookie, that's one type of cookie, but cookies are used virtually in any website to log in, for example.
Yeah.
It stores a piece of session information, so you can't really say cookies are illegal generally.
It's anything if
It wouldn't work.
well, yeah, and that then becomes the part of the exemption. Anything that fulfills that definition on there
Right.
is the starting point is you can't do it unless. So it's a typical sort of European directive of along the privacy line saying, well, we don't want you to do that unless it's basically up front and people know what it's about. What you have to do is if you're using a cookie, then you've got to really all it is you have to provide clear and comprehensive information about the purpose of the cookie and what it's going to do. That really then gets you around it. Now, how comprehensive that has to be, what we're talking about here is really cookie statements and giving the user the option to refuse the cookie if they want to. I appreciate that's going to possibly prevent them from doing whatever it is that they want to do on the website. So be it. The user says, well, that's fine. If they can't do, if they don't want the cookie and they can't use it, can't use the website, then that's their choice to not be able to use the website. I've made the mention of a cookie statement there, which I think you'll actually find a lot of these on certainly trading sites. You get a little pop-up that says, well, install this cookie on your site. It's going to say where you've been and what follow you around. That sort of stuff. The exemption, when you don't need the statement, is basically where the cookie is for the sole purpose of carrying out or facilitating the transmission of electronic communications. So that's shopping basket, that kind of thing, maybe, as I've said there, or strictly necessary for the provision of the requested service. So if it's essential and you can't do it without it, and that's all it's doing, that's fine.
Yeah.
So if you're in a business, explicit consent probably the most vital one, and that's explicit is an important word there. It's not just consent; it's explicit consent, which is defined as being freely given and an informed indication of the subject's wishes. And what that means is that the individual concerned has to know why the data is being processed, and there can't be any coercion or any presumption of consent. So it has to be explicit in the sense that it's there. There's no messing around with it. I think the important thing to take is that explicit consent cannot be inferred or assumed.